Before we begin, a quick and important disclaimer. The information presented in this video is for educational and entertainment purposes only. We are discussing sociological trends, historical data, and psychological frameworks as they appear in academic literature. This content does not constitute legal, financial, or psychological advice. Divorce laws vary significantly by state, and individual circumstances require professional consultation. You must conduct your own due diligence and consult with a licensed attorney or qualified professional regarding your specific situation. Statistically speaking, you are currently standing on a fault line that most men never see until the ground beneath them actually splits open. In the United States, current sociological data suggests that approximately 70% of divorces are initiated by women, a figure that climbs toward 90% when looking at college-educated couples. If you are an American man, you have been raised on a diet of cultural myths about happily ever after. Yet the academic textbooks used to train the world's leading family therapists and sociologists tell a radically different story. There is a massive disconnect between what the average man thinks he knows about the end of a marriage and what the peer-reviewed data actually reveals about the survival of the male identity post-separation. We are entering a masterclass on the academic reality of the American divorce. By the end of this deep dive, you will understand the structural, psychological, and financial frameworks that textbooks usually reserve for graduate students, giving you a clinical perspective on a process that most men experience only as a chaotic emotional whirlwind. The fundamental problem we are solving today is the information asymmetry gap. In academic terms, men often enter the divorce process with significantly less emotional and social preparation than their partners. While textbooks on family dynamics highlight that women often engage in pre-divorce processing, mentally and logistically preparing for years, men are frequently caught in what researchers call the sudden onset crisis. This video is designed to bridge that gap using the same datasets and theoretical models used by experts. We aren't looking at how-to guides. We are looking at the why and the how of the system itself. Let's begin by deconstructing the sociological framework of the American divorce. According to standard family sociology textbooks, the concept of marriage has shifted from a companionate model to an individualistic model. In the companionate model, which dominated the mid-20th century, the success of a marriage was measured by how well the unit performed its roles, the provider and the nurturer. However, since the 1970s, we have moved into the individualistic marriage era. In this framework, the marriage is only considered successful as long as it facilitates the personal growth and self-actualization of both individuals. For men, this shift is a historical trap. Academic case studies show that many men still operate under the internal logic of the companionate model. They believe that if they provide, protect, and remain faithful, the contract is secure. Meanwhile, the legal and social reality operates on the individualistic model, where lack of fulfillment is a valid and frequent driver for dissolution. When you look at textbooks like The Sociology of Families by David Newman, you see that the legal shift to no-fault divorce in 1969 wasn't just a change in law. It was a fundamental re-engineering of the male social contract. Historically, divorce required a wronged party. You had to prove adultery, cruelty, or abandonment. This created a barrier to entry that protected the stability of the family unit at the expense of individual happiness. Today, the academic consensus is that the barrier to exit is lower than it has ever been in human history. For the American man, this means the potential outcomes of his marriage are no longer tied to his performance of traditional duties, but to a subjective metric of partner satisfaction that is notoriously difficult to quantify or predict. Now, let's pivot to the psychological impact model, specifically focusing on role exit theory. When a man loses his role as a husband and a full-time father, he undergoes what sociologists call identity stripping. In many academic texts, it is noted that men tend to centralize their social identity within the nuclear family. Unlike many women, who historically maintain broader emotional support networks, men often have singular source intimacy. This means their wife is their only confidant. When that source is removed, the data shows a significant spike in social isolation metrics. Case studies in masculine psychology suggest that men often experience a delayed response. While the initiator of the divorce has likely already processed the loss, the man is often just beginning the shock and denial phase of the Kubler-Ross model. This puts him at a massive disadvantage in the legal and negotiation phases. If you are making life-altering decisions about your assets, your home, and your children while in the midst of an acute neurological stress response, the potential for long-term negative outcomes increases exponentially. Let's look at the financial data through the lens of the feminization of poverty versus the masculine wealth gap. Traditional textbooks often focused on how divorce negatively impacted women's finances, which led to the creation of current alimony and child support structures. However, modern longitudinal studies, such as those published in the Journal of Marriage and Family, show a more nuanced picture. While women may see a more immediate dip in household income, men often face a long-term asset depletion that affects their ability to retire or rebuild. Specifically, we must discuss the divorce penalty in career trajectory. For men in high-stress American corporate or academic environments, the cognitive load of a divorce can lead to what researchers call presenteeism, being physically at work but mentally absent. This leads to a historical trend where divorced men see a slowing of promotion rates compared to their married or single peers. It isn't just about the check you write to an ex-spouse. It's about the opportunity cost of the years spent in legal and emotional recovery. Furthermore, the residential parent dynamic is a cornerstone of American family law textbooks. Even though many states have moved toward 50-50 shared parenting, as a default, the actual historical trends show that the primary caretaker status is still disproportionately awarded based on gendered patterns of labor that existed during the marriage. If a man focused on career growth while his wife focused on the home, the court's best interests of the child standard often reinforces that status quo, leading to the man becoming a visitor in his children's lives. This is described in academic literature as parental disenfranchisement, and it is one of the leading causes of the high rates of depression and health decline in divorced American males. To understand how to navigate this, we must look at the game theory of negotiation, as applied to family law. In academic textbooks on conflict resolution, divorce is often categorized as a zero-sum game initially, though the goal of mediation is to turn it into a non-zero-sum game. A zero-sum game is one where one person's gain is the other's loss. If you are fighting over a fixed pool of assets, every dollar she gets is a dollar you lose. Most men approach this with a rational actor mindset, assuming that if they are fair, the other side will be fair. However, textbooks on high-conflict personality dynamics warn that when the emotional stakes are this high, rational choice theory often goes out the window. In this first part of our deep dive, we have established the foundational reality. The American divorce system is a complex intersection of 19th century moral codes, 20th century legal shifts, and 21st century psychological realities. You are not just dealing with a breakup. You are dealing with a structural realignment of your entire existence, as defined by the most rigorous academic standards. We are going to move forward by looking at the biological stress response of the male body during legal proceedings, an area of study that explains why so many men make fatal negotiation errors in the first 90 days. We will examine how cortisol levels and sleep deprivation literally rewire your brain to seek peace at any price, a psychological state that can lead to decades of financial and personal regret. This is the academic lens on the most difficult transition a man can face. Imagine you are a 38-year-old software architect named Michael living in Austin, Texas, in June 2026. Michael has spent the last 15 years building a life that looks like a blueprint for American success. He has a 4-bedroom home, 2 children, and a retirement account that was finally beginning to show the benefits of compound interest. One Tuesday evening, his wife sits him down and explains that she is no longer happy and has already retained counsel. In that exact moment, Michael's brain undergoes a physiological shift that academic textbooks in neurobiology call the amygdala hijack. His prefrontal cortex, the part of the brain responsible for complex decision-making and logical reasoning, essentially goes offline. His body is flooded with cortisol and adrenaline. In this state, Michael is biologically incapable of making sound financial or legal decisions, yet the American legal system demands that he begin doing exactly that within 72 hours of being served. This neurological state leads to a phenomenon documented in sociological case studies as the peace at any price fallacy. Because the pain of the transition is so acute, men like Michael often agree to unfavorable settlement terms just to stop the bleeding. They believe that by being overly generous or yielding on critical assets, they can preserve a sense of nobility or perhaps even win back the favor of their spouse. However, historical trends in family law negotiations suggest that once a settlement is signed, it is nearly impossible to reverse. The court sees a signature not as a cry for help or a result of temporary emotional distress, but as a binding contract between two rational actors. Let's look at the actual data regarding the cost of this emotional haste. In a standard American divorce, the division of assets often hinges on the valuation of the primary residence and retirement accounts. According to current 2026 market data, real estate in tech hubs like Austin has become a primary driver of net worth. If Michael agrees to vacate the home and cover the mortgage while his wife stays with the children, he has effectively doubled his living expenses overnight without a corresponding increase in income. Academic textbooks on financial planning during marital dissolution call this the liquidity trap. A man may have high net worth on paper, but if his capital is tied up in a home he no longer inhabits and a 401k he cannot touch without penalty, he becomes functionally insolvent. This insolvency is a primary driver of the mental health decline observed in men post-divorce. Step by step, the academic literature suggests that the first move a man must make is not a legal one, but a physiological one. You must stabilize the nervous system to regain access to your logical faculties. In clinical terms, this is known as cognitive stabilization. Without it, you are a vulnerable negotiator. Imagine Michael's situation if he fails to stabilize. He meets with a mediator and agrees to pay a percentage of his gross income in support that does not account for the rising cost of health insurance or the inflationary pressures of 2026. He assumes his income will always go up. He does not factor in the potential outcomes of a corporate restructuring or a health crisis. He is negotiating from a place of fear and guilt rather than data. Historical trends also show a significant gender gap in what textbooks call social capital preservation. During a marriage, the social calendar is often managed by the wife. When the split occurs, the man frequently finds himself socially orphaned. His friends were actually the husbands of his wife's friends. Case studies from the University of Chicago indicate that men lose approximately 60% of their active social circle within the first year of a divorce. This isolation isn't just an emotional burden. It is a tactical disadvantage. In the professional world of 2026, your network is your net worth. As Michael loses his social anchors, his professional performance begins to slip. He misses deadlines. He becomes irritable in meetings. His supervisor notices a decline in engagement. This is the cascading effect of identity stripping mentioned in the previous section. To combat this, academic frameworks suggest the immediate construction of a shadow support network. This is not a group of friends to drink with, but a tactical team of professionals and objective peers who have navigated the same system. In the context of a deep dive masterclass, we must emphasize the role of the forensic accountant. Many men believe they have a handle on their finances, but modern household economics in 2026 are incredibly complex. From recurring digital subscriptions and shared cloud storage to the tax implications of cryptocurrency holdings and home equity lines of credit, the margin for error is razor thin. Consider a case study of an educator named David in Ohio. David assumed that his pension was a protected individual asset. He did not realize that under the laws of many states, the portion of the pension earned during the years of marriage is considered marital property. Without a clinical understanding of the law, David entered negotiations assuming he was protecting his future, only to find that he was effectively funding two separate retirements on a single salary. The textbook lesson here is that ignorance of the law is not just a legal hurdle. It is a financial catastrophe. Furthermore, we must address the concept of parental gatekeeping. This is a term used in developmental psychology textbooks to describe a situation where one parent controls the other parent's access to the children. For men, the potential outcomes of a passive approach to custody are grim. If a man moves out of the family home without a temporary custody order in place, he inadvertently establishes a new status quo. The court tends to favor stability for the children. If the children have been living primarily with the mother for 6 months while the father is in a studio apartment, the court may rule that changing this arrangement would be disruptive. Thus, the father is relegated to every other weekend status, not because he is unfit, but because he allowed a temporary emotional decision to become a permanent legal precedent. This brings us to the importance of documentation, or what academics call the contemporaneous record. In a high-stakes environment, memory is a poor witness. Textbooks on litigation support emphasize that the person with the best records usually has the most leverage. If Michael can show a 2-year history of being the parent who handles the morning routine, medical appointments, and school communications, he challenges the traditional gendered narrative of the primary caretaker. But this requires a level of detail that most men, distracted by the trauma of the split, fail to maintain. As we move deeper into this masterclass, we have to confront the most uncomfortable truth found in these textbooks. The system is not designed for fairness. It is designed for closure. The state's primary interest is ensuring that neither party becomes a ward of the state and that the children are provided for. Beyond that, the nuances of your personal sacrifices or your partner's infidelities are often irrelevant to the cold calculus of the bench. If Michael wants to survive 2026 with his identity and his assets intact, he has to stop seeing himself as a husband in crisis and start seeing himself as a lead strategist in a complex reorganization. But there is a silent killer in this process that no one talks about until it is too late. It is a psychological trap that can turn a civil separation into a decade-long war, and it is hidden in the very language we use to describe our homes. In the next part, we are going to strip away the emotional facade of the family residence and look at the brutal mathematics of the silver bullet defense, a tactic so devastating that it can end a man's legal standing before he even enters a courtroom. You need to know what it is before it is used against you. The silver bullet defense is a term often whispered in the corridors of family law offices and detailed in modern legal textbooks as a high-stakes litigation strategy. In the context of American family law in 2026, it refers to the use of an ex parte restraining order or an order of protection to immediately remove a spouse from the family home and restrict their access to children without a full hearing. Imagine if Michael, our architect from Austin, returns home to find a police officer standing on his porch. He is served with paperwork alleging that his presence in the home constitutes an immediate threat to the safety of the household. Within 5 minutes, Michael is barred from his property, separated from his children, and his legal standing is fundamentally compromised before he has even spoken to a judge. In academic literature, this is studied under the framework of procedural due process versus immediate safety protocols. The historical trend shows that courts, fearful of being held liable for domestic tragedies, will almost always err on the side of caution. This means an accusation, even without immediate physical evidence, can trigger a temporary order of protection. For the American man, the potential outcomes of this maneuver are catastrophic. Once an order is in place, the man is often prohibited from possessing firearms, contacting his children, or even entering his place of work if his spouse works nearby. This creates a psychological and legal vacuum. Case studies in domestic relations law highlight that the silver bullet is frequently used as a tactical nuclear option to establish what we previously called the status quo. If Michael is out of the house for 3 weeks while waiting for a hearing to contest the order, his spouse has successfully demonstrated that she can maintain the household and care for the children without him. When they finally do get to court, the judge sees a functioning, stable environment and is hesitant to disrupt it. The textbook lesson here is that the primary residence is not just a building. It is the center of gravity for your legal rights. If you lose control of the residence, you often lose the gravitational pull necessary to maintain joint custody. Let us look at the granular mechanics of this. In 2026, digital evidence is the primary currency of these orders. Academic texts on digital forensics and family law explain how out-of-context text messages, recordings made in the heat of an argument, or even shared location data can be used to construct a narrative of harassment or stalking. If Michael sends 20 texts in 1 hour because he is panicked about being locked out of his bank account, those texts are no longer seen as a man in distress. They are presented in court as evidence of obsessive, harassing behavior. This is why textbooks on litigation management emphasize the concept of radio silence. In a high-conflict divorce, every digital interaction is a potential exhibit. Now, imagine a different scenario involving a character named Christopher in Atlanta. Christopher is a project manager who understands the concept of risk mitigation. When his marriage begins to fail, he does not wait for a crisis. He applies the academic principle of preemptive transparency. He maintains a detailed log of all interactions and ensures that all sensitive conversations happen in the presence of third parties or via recorded digital platforms that provide a full, unedited context. Christopher is essentially building a defense against the silver bullet before the trigger is even pulled. He understands that in the eyes of the court, the person who presents as the most emotionally regulated and organized usually wins the day. We must also address the financial aspect of the silver bullet defense. When a man is removed from his home, he still bears the financial burden of the mortgage, utilities, and taxes on that property, while simultaneously paying for his own emergency housing. This is known in academic finance as the dual household deficit. For a man earning a median salary in 2026, this deficit is often unsustainable for more than 60 days. Historical trends show that men in this position are frequently forced into a settlement that essentially trades their long-term assets for short-term relief. They agree to waive their rights to a pension or a house in exchange for the lifting of a restraining order or the granting of visitation rights. Step by step, the textbook suggests that if a man suspects a silver bullet defense might be deployed, he must act with clinical precision. This includes securing personal documents, financial records, and sentimental items in a secure, off-site location. It involves changing all digital passwords and enabling multi-factor authentication on all accounts that are not legally shared marital property. It also means establishing a line of communication with a legal professional who can respond within minutes, not days. The goal is to move from a state of reaction to a state of anticipation. Another critical concept found in sociology textbooks is the weaponization of social services. In several case studies, the involvement of Child Protective Services is triggered by a strategic report during the peak of a custody battle. While these agencies are vital for the protection of children, the academic data reveals that a significant number of reports filed during active divorces are found to be unsubstantiated. However, the damage is done. The mere existence of an investigation can be cited in court as a reason to limit a father's unsupervised time. This is part of the broader framework of gatekeeping, where the legal system is used to create a barrier between the father and the child's developmental milestones. To counter this, we look at the psychological concept of parallel parenting. In high-conflict situations, traditional co-parenting, which requires frequent communication and collaboration, is often impossible. Academic texts suggest that parallel parenting, where each parent operates independently within their own sphere of influence and adheres to a strict, court-mandated schedule, is often the only way to protect the father's role. This reduces the surface area for conflict and limits the opportunities for one parent to use the silver bullet defense as a reaction to a perceived slight. This masterclass is designed to move you from the emotional realm into the strategic realm. The silver bullet defense is a tool of the system, and like any tool, its impact can be mitigated if you understand its mechanics. But there is another layer to this academic deep dive that is even more subtle and pervasive. It is the concept of the parental alienation syndrome, a theory that remains one of the most controversial topics in modern psychology textbooks. It is a slow, silent erosion of the bond between a man and his children that often leaves no physical evidence, but can result in a total loss of the relationship. As we progress, we will examine the actual scripts and behavioral patterns identified by child psychologists that signal when this erosion is happening. You need to know how to identify these patterns and, more importantly, how to document them in a way that is admissible in an American courtroom in 2026. This isn't just about winning a case, it's about preserving a legacy. In the next part, we will explore the brutal world of forensic psychological evaluations and how one 30-minute session with a court-appointed expert can permanently alter the trajectory of your children's lives. You cannot afford to walk into that room unprepared. The court-appointed psychological evaluation is often the most misunderstood and underestimated phase of a contested divorce. In academic textbooks on forensic psychology, this process is known as a custody evaluation or a best interest study. Imagine a clinical psychologist named Dr. Eris sitting across from Michael in a sterile office in downtown Austin. To Michael, this feels like a therapy session or a chance to vent about the injustices he has faced. To Dr. Eris, this is a data collection mission designed to fit Michael into a pre-existing psychological profile. In the American legal system of 2026, the recommendations of a court-appointed expert are followed by judges in approximately 80 to 90% of cases. This means that 30 minutes of conversation can carry more weight than a decade of active fatherhood. The primary academic framework used in these evaluations is the parent-child relationship schema. Evaluators look for signs of parental alienation, which is a controversial but heavily studied phenomenon where one parent uses psychological manipulation to distance the child from the other parent. However, the evaluation also looks for the man's level of insight. If Michael spends his entire session complaining about his ex-spouse's spending habits or infidelity, Dr. Eris will note a lack of child-centric focus. In forensic textbooks, this is categorized as poor emotional regulation. The evaluator is not there to determine who is the better person. They are there to determine who is the more stable psychological anchor for the child. Case studies from the University of Virginia's Family Stress Project suggest that men often fail these evaluations because they confuse the role of the evaluator with the role of a therapist. A therapist is there to validate your feelings. A forensic evaluator is there to test your fitness. For example, imagine if Michael is asked about his disciplining style. If he reacts defensively or provides vague answers, The evaluator may flag him for authoritarian tendencies. Conversely, if he is too permissive, he may be flagged for a lack of structure. The academic standard is authoritative parenting, a middle ground that combines high warmth with high expectations. If Michael hasn't read the literature on this, he is essentially walking into a high-stakes exam without the syllabus. Let's dive into the granular details of the psychological testing often involved, such as the MMPI-3 or the Minnesota Multiphasic Personality Inventory. This is a standardized psychometric test with hundreds of true or false questions. It is designed to detect everything from depression and paranoia to the tendency to present oneself in an overly favorable light, known as faking good. Academic texts on psychometrics warn that men under the stress of divorce often score high on the scale for defensiveness. In a clinical setting, this is understandable. In a forensic setting, a high defensiveness score can be interpreted as a lack of transparency or a personality disorder. This is a potential outcome that can lead to supervised visitation or a mandate for long-term counseling before unsupervised custody is even considered. Historical trends in 2026 show that the digital footprint is now a part of the psychological evaluation. Evaluators may request access to social media archives or communication logs. If Michael has posted even one aggressive comment on a forum or shared a meme that disparages the institution of marriage, it can be used as evidence of a hostile worldview. This is why textbooks on contemporary forensic practice emphasize the digital shadow. Your online life is seen as a window into your subconscious. For Michael, a project he worked on or a hobby he shared online in 2024 could be recontextualized by an evaluator in 2026 to suggest he is distracted or unstable. Step by step, the academic literature suggests that preparation for an evaluation must begin months in advance. This involves what is called behavior modification through documentation. If Michael wants to prove he is an active parent, he shouldn't just say it. He should have a calendar that tracks every school play, every pediatrician visit, and every nightly reading session. In the eyes of a forensic expert, data beats anecdotes every time. This is the contemporaneous record we discussed earlier, applied to the psychology of the home. Now imagine a character named Robert in Seattle. Robert is a high-level executive who is used to controlling the narrative in boardrooms. When he enters his custody evaluation, he tries to charm the psychologist. He uses professional jargon and tries to direct the conversation. In the evaluator's report, this is described as a narcissistic personality trait or an attempt to manipulate the clinical process. Robert's strength in the corporate world becomes his greatest liability in the family court. The textbook lesson here is the necessity of radical humility. The most successful potential outcomes occur when a man demonstrates a willingness to learn, an ability to co-parent despite conflict, and an unwavering focus on the developmental needs of the children, rather than his own ego. We must also address the concept of the observation session. This is where the evaluator watches the father interact with the children. Academic textbooks on attachment theory focus on the secure base. Does the child look to the father for comfort? Is the interaction natural or performative? Many men, feeling the pressure, try to be the fun parent during these sessions, bringing toys or planning elaborate activities. Forensic experts often see through this. They are looking for the mundane rituals of parenting, setting boundaries, cleaning up, and engaging in active listening. If Michael spends the hour being a cruise ship director, he fails to demonstrate the stability required for primary or even equal custody. The cost of a poor evaluation is not just legal, it is financial. A recommendation for supervised visitation often comes with the requirement that the father pays for the supervisor, which can cost upwards of $100 per hour in 2026. Furthermore, contesting a negative report requires hiring a rebuttal expert, another psychologist, to find flaws in the first one's methodology. This leads to the expert war, a phase of divorce that can drain a retirement account in a matter of months. As we move forward, we have to look at how these psychological profiles are used to determine child support and alimony. In many American states, there is a direct correlation between the percentage of time you spend with the children and the amount of money you transfer to your ex-spouse. The system creates a perverse incentive where custody is not just about the child but about the cash flow. In the next part, we are going to break down the cold, hard mathematics of the state guidelines. We will look at how the imputation of income works, where the court can decide you should be making more money than you actually are, and tax you on that imaginary income. This is the financial architecture of the divorce industry. And if you don't understand the formulas, you are essentially signing a blank check for the next decade of your life. You need to see the spreadsheets before the court sees your tax returns. The financial architecture of the American divorce system is built upon a foundation of standardized formulas that many men mistakenly view as a negotiation when, in reality, they are closer to an administrative calculation. In academic textbooks on family law and forensic accounting, these are often referred to as child support guidelines and spousal maintenance worksheets. Imagine a 35-year-old electrical engineer named James living in Charlotte, North Carolina, in 2026. James earns $140,000 a year. His wife has been a stay-at-home parent for 8 years. James assumes that because he pays for the mortgage, the cars, and the private school tuition, the court will look at his actual disposable income to determine what he can afford. However, the court uses a concept called the income shares model. This model assumes that the children should receive the same proportion of parental income that they would have received if the parents lived together. In James's case, the court does not care about his student loans or his high cost of living in a 2026 urban economy. The formula takes his gross income, subtracts a few standardized deductions, and arrives at a number. This leads us to one of the most significant pitfalls in masculine financial planning during a divorce: the imputation of income. Academic textbooks on matrimonial law define imputation as the process where a court assigns an income to a party who is currently earning less than they are capable of earning. Imagine if James, feeling the immense pressure and burnout of the divorce, decides to take a lower-paying job with less stress. He moves from his engineering role to a local consulting gig making $80,000. The court, citing historical trends in his earnings, may decide that James is voluntarily underemployed. They will calculate his support obligations based on his potential income of $140,000, even though his actual take-home pay is significantly less. This creates a financial deficit that can lead to rapid debt accumulation and long-term insolvency. Case studies in forensic accounting highlight that the imputation of income is not just applied to the breadwinner. It can also be applied to the non-working spouse. If James's wife has a degree in marketing but has not worked for a decade, a vocational expert can be hired to testify about her earning capacity in the 2026 job market. If the expert determines she could be earning $60,000, James's legal team can argue that her income should be imputed at that level, potentially reducing James's spousal support obligation. However, the cost of hiring this expert often runs into the thousands of dollars, making it a strategic calculation that requires a deep understanding of the cost-benefit ratio. Step by step, the academic literature suggests that a man must perform a comprehensive financial audit before any legal papers are even filed. This is not just about looking at bank statements. It is about understanding the tax treatment of different assets. In 2026, the tax implications of alimony have shifted significantly since the tax changes of 2018. For federal purposes, alimony is no longer deductible for the payer and is not considered taxable income for the recipient. This means that every dollar James pays in spousal support is a post-tax dollar. If he is in a 30% tax bracket, he actually has to earn about $1.40 to pay $1 of support. This hidden tax burden is what textbooks call the alimony trap. Men who do not factor this into their settlement negotiations often find themselves unable to meet their own basic living expenses despite having a high gross salary. Now, consider the case of a character named Marcus in Phoenix. Marcus has a significant portion of his wealth in restricted stock units and a diversified cryptocurrency portfolio. In many 2026 academic texts on equitable distribution, these are classified as complex assets. The difficulty lies in the valuation date. Does the court value the Bitcoin at the price it was when the divorce was filed, or at the price it is on the day of the final hearing? In a volatile market, this difference can represent hundreds of thousands of dollars. Marcus's mistake was assuming that his digital assets were private. However, modern forensic accounting tools used in 2026 can track blockchain transactions with high precision. If Marcus attempts to hide these assets, he faces the potential outcome of a fraud finding, which can result in the court awarding 100% of that asset to his spouse as a penalty. We must also examine the concept of the marital waste or dissipation of assets. Textbooks on domestic relations law define this as the use of marital funds for a non-marital purpose during the breakdown of the marriage. If Marcus spent money on a new hobby, a separate vacation, or even high-end dinners during the period of separation, the court can order him to reimburse the marital estate for half of those expenses. This is why financial experts emphasize the importance of the date of separation. From that moment forward, every dollar spent is under a microscope. Academic frameworks suggest opening a separate bank account and documenting every single transaction to prove that funds are being used for legitimate living expenses rather than the dissipation of assets. Furthermore, we need to address the long-term impact of the QDRO, or Qualified Domestic Relations Order. This is the legal instrument used to divide retirement accounts like a 401k or a pension. Many men see their retirement balance and think of it as a singular number. They do not realize that dividing these assets often involves complex actuarial calculations and significant administrative fees. Historical trends show that men who lose half of their retirement at age 45 rarely manage to recover the same level of wealth by age 65, due to the loss of time for compound interest to work. The academic lesson here is that $1 in a retirement account today is worth significantly more than $1 of current home equity, yet many men trade their retirement to keep the family house, a decision that textbooks often categorize as a long-term strategic error. The family house itself is often an emotional anchor that drags men into financial ruin. In the 2026 real estate market, with high interest rates and increased property taxes, the cost of maintaining a home can exceed 40% of a single person's net income. If Michael or James fights to keep the house to provide stability for the children, they may find themselves house poor, unable to afford the legal fees or the travel costs associated with visitation. Forensic accountants often refer to the house as a liability disguised as an asset during a divorce. The academic recommendation is often to sell the property and split the equity, allowing both parties to reset their cost of living to a sustainable level. As we conclude this part of the masterclass, it is clear that the financial side of divorce is a war of attrition fought with spreadsheets and tax codes. You are not just negotiating with an ex-spouse. You are navigating a state-mandated redistribution of wealth. But there is a factor that can override even the most precise financial planning, and it is the most unpredictable element in the entire process: the personal bias of the judge. In the next part, we are going to look at the sociology of the courtroom. We will examine the data on how different jurisdictions and individual judicial philosophies can lead to vastly different outcomes for men in identical financial situations. You will learn how to research a judge's past rulings and how to tailor your legal presentation to fit their specific worldview. Understanding the math is only half the battle. You also have to understand the person wearing the robe. The sociology of the courtroom is a variable that is often overlooked in traditional legal advice, yet it is a central pillar in academic textbooks on judicial behavior and legal realism. In the American legal system of 2026, the law is not just a set of rules. It is a set of interpretations made by individuals with their own professional backgrounds, social values, and cognitive biases. To navigate a divorce successfully, a man must understand the concept of judicial discretion. This is the power given to a judge to make decisions based on their own estimation of what is fair and equitable within the bounds of the law. While state statutes provide the skeleton, the judge provides the flesh. This means that two men with identical incomes, identical assets, and identical parenting histories could walk into two different courtrooms and walk out with vastly different lives. Imagine a 42-year-old middle manager named David in Denver, Colorado. David's case is assigned to Judge Miller, a jurist who, according to historical trends and public records, spent 20 years as a child advocate before being appointed to the bench. For Judge Miller, the developmental needs of the child are the absolute priority, often superseding the financial equity between the parents. If David's legal team presents a case that focuses heavily on his right to half the assets but neglects to provide a detailed, child-centric parenting plan, he is likely to face a less favorable potential outcome. In contrast, if David were in front of Judge Thompson, a former corporate litigator with a reputation for strict adherence to mathematical formulas and property rights, the financial arguments would carry significantly more weight. Academic textbooks on legal research and advocacy suggest that a man must perform a judicial profile audit. This involves reviewing the judge's past rulings, their written opinions, and even their participation in legal seminars. In 2026, many legal databases provide analytics on how specific judges tend to rule on issues like alimony duration or the imputation of income. For David, knowing that Judge Miller rarely grants permanent spousal support, but is very strict about health insurance coverage for children, allows him to tailor his settlement proposal. He can offer to cover all medical expenses in exchange for a shorter alimony term, playing directly into the judge's established judicial philosophy. This is not about manipulation. It is about the effective communication of facts within a specific cognitive framework. Case studies in courtroom psychology also point to the importance of the witness stand demeanor. When a man testifies in an American family court, he is under a level of scrutiny that textbooks call the credibility assessment. This is not just about telling the truth. It is about the perceived emotional stability and cooperativeness of the witness. Imagine if David is cross-examined about his past social media posts or a heated argument he had with his spouse. If he becomes defensive, raises his voice, or blames his spouse, he is reinforcing a negative stereotype often found in domestic litigation literature: the high-conflict male. However, if he remains calm, acknowledges his mistakes, and redirects the focus back to the well-being of his children, he demonstrates the psychological maturity that judges equate with being a fit primary parent. Step by step, the academic literature suggests that the physical environment of the courtroom also plays a role in the outcome. This is known as the environmental psychology of the law. The way you dress, the way you sit, and even who you have sitting behind you in the gallery sends a message to the judge. If David brings his new girlfriend to a custody hearing, it may be interpreted as a lack of sensitivity to the children's transition, regardless of the legal relevance. Textbooks on trial advocacy emphasize that every person in that courtroom is an observer contributing to the judge's final synthesis of the facts. Another critical factor is the role of the guardian ad litem, or the attorney for the child. In many 2026 jurisdictions, these individuals act as the eyes and ears of the judge. They perform home visits and interview teachers and doctors. Academic texts on child advocacy explain that the report of a guardian ad litem is often the single most influential document in a custody case. If David treats this person as an adversary or a nuisance, he is effectively alienating the judge's most trusted advisor. The strategic approach is to treat the guardian ad litem with the same level of professional respect and transparency as the judge themselves. Provide them with organized files, quick access to information, and a clear non-adversarial narrative of your parenting goals. We must also address the concept of the local legal culture. In many American counties, the community of family law attorneys and judges is small and interconnected. Textbooks on legal sociology note that the reputation of your attorney can significantly impact your case. If your lawyer has a reputation for being overly aggressive or for filing frivolous motions, the judge may view your entire case through a lens of skepticism. Conversely, an attorney who is known for being reasonable and settlement-oriented can often secure better potential outcomes during informal pre-trial conferences. This is why selecting an attorney based on their standing within the local bar is often more important than their win-loss record on paper. Now, consider the case of a character named Stephen in suburban Illinois. Stephen is a firefighter who works 24-hour shifts followed by 48 hours off. In a traditional courtroom, this schedule might be seen as a hurdle to 50-50 custody. However, by using academic research on non-traditional work schedules and child development, Stephen's legal team can argue that his schedule actually allows for more quality daytime interaction with his children than a typical 9-to-5 office worker. They can present a week-by-week calendar showing how Stephen can be the parent who handles school pickups and extracurricular activities on his days off. This is an example of using data to overcome a structural bias in the judicial system. Furthermore, we need to examine the impact of the social study. This is an intensive investigation into the social and economic conditions of both parents. Academic frameworks for these studies often include interviews with neighbors, employers, and extended family. For the American man, this is a moment where his social capital is put to the test. If David can produce a list of credible, professional references who can speak to his character and his role as a father, it provides a powerful counter-narrative to any negative claims made during the litigation. Historical trends show that men who have a strong, visible presence in their community and their children's lives fare much better in these social studies than those who have been more hands-off or isolated. As we move toward the final stages of the courtroom deep dive, we have to look at the post-judgment reality. A court order is only as good as its enforcement. Textbooks on post-decree litigation show that a significant portion of family law cases return to court within 3 years for modifications or contempt proceedings. If David wins the custody and financial terms he wants, but fails to adhere to the strict letter of the order, he risks losing everything in a subsequent hearing. The judge who was your ally today can become your most formidable critic tomorrow if you show a lack of respect for the court's authority. This brings us to a psychological phenomenon that textbooks call the winner's curse in family law. Sometimes winning a lopsided victory in court creates such deep resentment in the other parent that it leads to a lifetime of high-conflict co-parenting and parental alienation. In the next part, we are going to explore the academic strategies for long-term co-parenting success. We will look at the science of parallel parenting versus cooperative parenting, and how to build a communication firewall that protects your peace of mind and your children's emotional health. You will learn how to turn a court order into a functional, sustainable life. The battle in the courtroom is over, but the marathon of parenting is just beginning. Transitioning from the high-intensity environment of a courtroom to the daily reality of a post-divorce household requires a fundamental shift in strategy. In academic textbooks on family systems theory, this phase is known as the reorganization of the family structure. For the American man in 2026, this is where the theoretical legal victories meet the practical challenges of co-parenting. The objective is to move from a state of litigation to a state of operation. This requires the implementation of a communication firewall, a psychological and digital barrier designed to minimize conflict while maximizing the efficiency of information exchange. Imagine a 44-year-old project manager named Brian in Denver. Brian has just secured a joint custody arrangement that gives him his children every other week. In the first few months, Brian attempts to maintain a friendly, conversational relationship with his ex-spouse, much like they had early in their marriage. He sends texts about the kids' funny comments, asks for advice on school projects, and tries to engage in small talk during exchanges. However, academic case studies in high-conflict divorce suggest that this level of openness often leads to a phenomenon called boundary blurring. For Brian, a simple text about a missed soccer practice quickly spirals into a retrospective argument about the reasons for the divorce. To prevent this, academic literature on conflict resolution recommends the adoption of parallel parenting. Unlike cooperative co-parenting, which relies on high levels of communication and shared decision-making, parallel parenting allows each parent to operate independently within their own home. You are not two departments in the same company anymore. You are two separate companies with a single shared client, the child. This means that within Brian's home, his rules, his diet for the children, and his weekend activities are his business. He does not seek approval, and he does not offer explanations for routine parenting choices. This reduces the surface area for conflict by eliminating the need for constant negotiation. The communication firewall is the primary tool of the parallel parent. In 2026, this is often facilitated by court-mandated parenting apps. Academic texts on technology-mediated communication explain that these platforms are designed to create a contemporaneous record that is admissible in court. When Brian uses an app instead of a personal text message, the tone of the conversation naturally shifts. The awareness that a judge or a guardian ad litem could eventually read these messages acts as a biological governor on impulsive emotional responses. Step by step, the protocol for this firewall involves 3 rules. It must be brief, informative, and neutral. If the message does not pertain to a specific logistical need for the children, such as a medical appointment or a change in pickup time, it does not get sent. Now, consider the psychological concept of the gatekeeping barrier. In many sociological studies of American families, the mother has historically functioned as the primary gatekeeper of information regarding the children's social and educational lives. After a divorce, a man often finds himself in an information vacuum. Brian might realize 3 weeks late that his daughter has a parent-teacher conference, or that his son needs new cleats for baseball. Academic textbooks on masculine parenting identity emphasize the importance of proactive information gathering. You cannot rely on your ex-spouse to be your secretary. This means Brian must establish direct, independent relationships with the school portal, the pediatrician's office, and the coaches. In the eyes of the academic framework, a man's level of engagement is measured by his direct access to data, not by his ability to extract that data from an uncooperative co-parent. Let us look at a case study involving a character named Anthony in Chicago. Anthony noticed that every time he picked up his children for his scheduled time, his ex-spouse would initiate a conversation about late child support or a disagreement about the kids' haircuts right in front of the children. This is identified in developmental psychology textbooks as triangulation, where the child is physically and emotionally caught in the crossfire of parental conflict. To solve this, Anthony implemented a neutral zone exchange. Instead of a front porch handoff, the exchange takes place at the children's school or a public library. Anthony picks the kids up from school on Friday afternoon, and the mother picks them up from school on Monday morning. They never have to see or speak to each other. Historical trends show that this transition method significantly lowers the stress hormones in children, as it eliminates the visual cues of parental tension. Furthermore, we must address the concept of the parental alienation baseline. Academic research suggests that alienation is not always a grand conspiracy. Often, it is a series of small, repetitive behaviors. It is the sigh when the father's name is mentioned. It is the habit of calling the child during the father's time just to check in, which subtly communicates that the child is not safe or that the father is not competent. For a man like Brian or Anthony, the academic response is not to counterattack, which only reinforces the child's sense of conflict. Instead, the focus is on the secure attachment. Attachment theory textbooks state that the most effective way to combat alienation is to provide a consistent, calm, and emotionally available environment. You do not win by proving the other parent is bad. You win by proving, through years of consistent action, that you are a reliable and loving fixture in the child's life. In the financial realm of post-divorce life, we must discuss the audit of incidental expenses. Most child support orders cover the basics, but the real conflict often arises in the gray areas. Summer camps, orthodontic work, or car insurance for a teenager. Academic texts on matrimonial finance suggest the use of a shared expense ledger. Every receipt is uploaded, and the percentage split, usually determined by the original court order, is calculated automatically. This removes the emotional weight of asking for money. For Anthony, this meant setting up a dedicated bank subaccount specifically for these child-related expenses, ensuring that marital funds are never commingled with post-divorce liabilities. Another critical factor found in sociology textbooks is the management of the extended family. During a divorce, grandparents, aunts, and uncles often feel a pull to take sides. However, historical data indicates that children who maintain strong bonds with both sides of their extended family have better long-term psychological potential outcomes. A man must act as the bridge for his side of the family. Brian ensures that his parents have their own scheduled time with the grandkids, independent of his parenting time. This reinforces the idea that while the marriage has ended, the family ecosystem remains intact. As we move deeper into this masterclass, we have to address the silent struggle of the American man, the rebuilding of the self. In academic terms, this is called post-traumatic growth. After years of defining yourself as a husband and a father within a specific household, you are now tasked with defining your identity in a new space. Many men rush into new relationships to fill the void, a move that textbooks on family transition warn can complicate legal proceedings and confuse children's adjustment. In the next part, we are going to explore the sociology of the reset. We will look at the data on how long a man should wait before introducing a new partner to his children, and how the legal system in 2026 views new romantic interests in the context of custody modifications. We will also examine the science of environmental design, how to set up your new home to reflect your values and provide a sense of permanence for your children. You have survived the legal storm. Now you must build a structure that can weather the years to come. The sociology of the reset is not merely about finding a new place to sleep. It is about the structural re-engineering of a man's environment to support a new social identity. In academic textbooks on environmental psychology, this is known as place attachment and identity signaling. For the American man in 2026, your new residence is the most powerful piece of nonverbal evidence you own. It signals to your children, your ex-spouse, and the legal system whether you are a man in transition or a man who has established a permanent, stable foundation. Imagine a 40-year-old civil engineer named Kevin in Indianapolis. Kevin has moved into a high-rise apartment that is convenient for his commute, but lacks a dedicated space for his two daughters. He assumes that since they are only there every other weekend, they can share a pull-out sofa or sleep in his room while he takes the couch. However, textbooks on child development emphasize the concept of the environmental anchor. If children do not have a dedicated, personalized space in their father's home, containing their own clothes, toys, and a sense of privacy, they subconsciously view themselves as guests rather than residents. This psychological distance can lead to what researchers call visitation resistance. In the eyes of the court in 2026, Kevin's living situation is a data point. If his ex-spouse files for a modification of custody, her legal team will argue that Kevin's environment is not conducive to the well-being of the children. Case studies in family law suggest that the potential outcomes for men who fail to prioritize child-centric housing are often a reduction in overnights. Step by step, the academic recommendation for the reset is to prioritize the children's environment over your own luxury. This means that even in a smaller two-bedroom home, the largest bedroom or the most decorated space should belong to the children. It signals to the legal system that your identity as a father is not a part-time role, but a permanent structural reality. Now, let us examine the sociology of new relationships, specifically the introduction of a new partner. This is a high-stakes area governed by what academic literature calls the repartnering interval. In the high-conflict environment of 2026, introducing a new romantic interest too early can trigger a legal phenomenon known as the morality clause or a cohabitation restriction in your divorce decree. Imagine a character named Derek in Miami. Derek begins dating 6 months after his separation and introduces his new girlfriend to his son within weeks. Textbooks on family transition and step-family dynamics warn that this creates a cognitive dissonance for the child, who is still mourning the loss of the nuclear family unit. Furthermore, from a legal perspective, Derek has just handed his ex-spouse a catalyst for litigation. Historical trends show that the introduction of a new partner is the #1 trigger for a return to court. The ex-spouse may allege that the new partner is a safety risk, or that their presence is emotionally damaging to the child. Academic frameworks suggest a waiting period of at least 6 to 12 months of exclusive dating before an introduction occurs. This is not about asking for permission, it is about risk mitigation. You are protecting your legal standing by ensuring that your personal life cannot be used as a weapon against your custodial rights. Let us look at the granular details of the introduction protocol found in psychological textbooks. The first meeting should be in a neutral, public space and should be brief. The goal is to avoid what researchers call the replacement narrative, where the child feels the new partner is trying to take the mother's place. By following a clinical, slow-roll approach, Derek can demonstrate to the court that he is making decisions based on developmental milestones, rather than emotional impulsivity. Beyond relationships, we must address the concept of post-traumatic growth in the professional sphere. Divorce is often cited in academic textbooks as one of the most significant life stressors, second only to the death of a spouse. This stress often manifests in the workplace as decreased productivity or emotional volatility. For a man in 2026, your career is your primary engine of recovery. You cannot afford to let the divorce jeopardize your earning capacity. Case studies in organizational psychology suggest that the most successful potential outcomes for men involve a strategic disclosure to their employers. This is not a request for sympathy, but a professional heads-up regarding a temporary logistical shift. By framing the divorce as a reorganization of your personal infrastructure, you maintain your professional authority while securing the flexibility needed for court dates and parenting transitions. This prevents the perception of underperformance and reinforces your image as a high-functioning leader. We must also discuss the environmental design of your personal health. Historical data shows that divorced men are at a significantly higher risk for cardiovascular issues and depression. Academic texts on masculine health emphasize the necessity of the physical reset. This involves the intentional creation of a routine that prioritizes sleep, nutrition, and physical exertion. For Kevin or Derek, the gym is not just about aesthetics. It is a laboratory for stress management. When you are physically disciplined, you are more likely to remain emotionally disciplined during a high-conflict mediation or a difficult exchange with an ex-spouse. Furthermore, we need to address the concept of the social audit. In your new life, your old social circle may no longer fit your new reality. Textbooks on social network analysis show that men who successfully navigate a divorce often build a new secondary network of peers who are also in a post-divorce phase. This provides a communal knowledge base that your married friends cannot offer. This isn't about wallowing in the past. It's about tactical information sharing. Who are the best mediators in Indianapolis? How do you handle a teenager who is being influenced by parental alienation? These are questions best answered by a network that understands the specific sociological terrain of the American man in 2026. Finally, let us look at the concept of the legacy build. In the academic study of generativity, men are driven to leave a mark on the future. Divorce can feel like the erasure of your legacy. However, the reset allows you to define your values independently. If you value education, your home becomes a place of learning. If you value outdoorsmanship, your parenting time is spent in the wilderness. You are no longer compromising your values to maintain a failing marriage. You are now the primary architect of your children's experience during your time. As we conclude this part of the masterclass, you must realize that the reset is the most creative act of your life. You are building a new world from the ground up, and every brick you lay must be placed with intention. But there is a hidden force that can still pull this new world apart, and it resides in the fine print of your final decree. It is the world of post-decree litigation and the reality of the forever war. In the next part, we are going to look at the legal mechanics of modifications, We will examine how a change in your income or a move by your ex-spouse can restart the entire legal process. You need to know how to build a decree that is not just a resolution for today, but a fortress for the next decade. The ink on the paper is dry, but the legal landscape is always shifting. The final decree in an American divorce is often perceived as the finish line, but in the world of academic family law and sociology, it is actually the commencement of the post-judgment phase. Textbooks on civil procedure and domestic relations describe the final judgment as a living document, subject to the gravitational pull of changing life circumstances. For a man navigating the legal landscape of 2026, understanding the mechanics of post-decree litigation is the difference between a stable future and a decade of recurring courtroom battles. This phase is dominated by the concept of the substantial change in circumstances. This is the legal threshold required to reopen a case for the modification of child support, alimony, or custody. Imagine a 45-year-old sales director named Gregory in Philadelphia. Gregory signed his final decree in late 2024, agreeing to child support based on his high-performing commission structure at the time. However, by May 2026, the economic sector he services has shifted, and his commissions have dropped by 40%. Gregory assumes that because his income has decreased, his obligation automatically adjusts. This is a critical misconception. In the American legal system, support obligations remain at the decreed level until a formal motion for modification is filed and granted. Academic textbooks on matrimonial finance refer to this as the accrual of arrears. If Gregory simply pays what he can afford without a court order, he is technically in contempt of court, and the unpaid balance becomes a non-dischargeable debt that can lead to the suspension of his driver's license or professional credentials. The potential outcomes for Gregory depend on his ability to prove that his income reduction is involuntary and permanent. Case studies in family law show that courts are deeply skeptical of sudden income drops following a divorce. Gregory must provide a forensic trail of evidence, layoff notices, industry data showing a broad market downturn, and a log of his efforts to maintain his previous earning level. This is the implementation of the professional transparency framework we discussed earlier. The court is looking to ensure that the man is not engaging in strategic underemployment to avoid his financial responsibilities. Step by step, the academic literature suggests that the best defense against post-decree volatility is a robustly drafted original decree. This is what experts call a future-proofed settlement. A common area of failure in these documents is the lack of specificity regarding the relocation of a parent. In 2026, remote work and geographic mobility are at an all-time high. Imagine if Gregory's ex-spouse decides to move 300 miles away for a new job opportunity. Without a specific radius clause or a relocation protocol in the original decree, Gregory faces an uphill battle to prevent the move or to maintain his parenting time. Textbooks on family law emphasize that the time to litigate a move is before it happens. A future-proof decree should include a requirement for a 60-day notice of intent to move and a preset adjustment to the visitation schedule and travel cost allocation in the event of a relocation. Now, consider the case of a character named Thomas in San Diego. Thomas has managed to rebuild his life and is now earning significantly more than he was during the divorce. He is worried that his ex-spouse will file for an upward modification of child support. Academic frameworks on child support caps provide a potential shield here. In many states, once parental income exceeds a certain high earner threshold, the formulaic approach to support ends and the court must look at the actual proven needs of the child. Thomas's strategy involves meticulously documenting the expenses associated with the children's lifestyle to ensure that any increase in support is tied to their well-being rather than a general redistribution of his new wealth. Another frequent driver of post-decree litigation is the modification of custody based on the child's preference. As children enter their teenage years, the American legal system begins to give more weight to their input. Sociology textbooks on adolescent development explain that teenagers often seek the path of least resistance. If one parent provides a household with fewer boundaries, the teenager may express a preference to live there. For Thomas, this means that his parenting style must balance the authoritative structure we discussed in previous sections with a high degree of relational investment. If he becomes the parent of only rules and no connection, he risks a custody modification initiated by his own child. We must also examine the concept of the life insurance and security for support clause. Most decrees require the payer to maintain a life insurance policy to secure the child support and alimony. In 2026, the cost of these policies is a significant factor. Academic texts on insurance law and divorce recommend that the man should own the policy himself rather than having the ex-spouse own it, providing him with control over the premiums and the ability to adjust the coverage as the financial obligation naturally decreases over the years. Failing to monitor these administrative details can lead to a contempt filing years after the divorce is finalized. Historical trends also show a rise in what academics call vindictive litigation. This is where one party uses the court system as a tool of harassment, filing motion after motion for minor infractions. Textbooks on legal ethics and court management suggest that the remedy for this is the request for attorney fee shifting. If Thomas can prove that a motion was filed in bad faith or without a legal basis, the court can order the other party to pay his legal fees. This creates a financial disincentive for the ex-spouse to continue the forever war. This is part of the broader strategy of building a legal fortress. You must make it more expensive and difficult for the other side to attack you than it is for them to follow the decree. The psychological impact of the forever war is documented in clinical studies as chronic litigation stress. Men who remain in the legal system for 5 or 10 years post-divorce show higher rates of burnout and physical health decline. The academic recommendation is the use of a parenting coordinator. This is a court-appointed professional, often a former lawyer or psychologist, who has the authority to make binding decisions on minor disputes like holiday scheduling or extracurricular activities without the parties having to go back to a judge. For Thomas and Gregory, the parenting coordinator acts as a circuit breaker, preventing small disagreements from escalating into full-scale legal battles. As we reach the conclusion of this section, it is clear that the final decree is not a set-it-and-forget-it document. It is a complex set of instructions for a decade-long operation. You have learned how to defend your assets, how to stabilize your psychology, and how to future-proof your legal standing. But there is one final piece of the puzzle that textbooks often leave for the very last chapter. It is the concept of the successful second family. In the final part of our masterclass, we are going to look at the data on remarriage and step-parenting. We will examine how a second marriage impacts your existing legal obligations and how to protect your new family from the shadows of your first divorce. You are about to enter the final stage of the journey, the long-term mastery of the modern American family structure. The concept of the blended family is perhaps the most complex social arrangement discussed in modern American sociology textbooks. When a man enters a second marriage after a divorce, he is not simply starting over. He is integrating two distinct historical timelines. In academic terms, this is known as the binuclear family system. For the American man in 2026, the potential outcomes of this integration depend heavily on his understanding of the legal and psychological boundaries between his first and second households. The shadow of the first divorce often manifests through financial obligations and the lingering legal authority of the original decree, which can create significant tension within the new union. Imagine a 48-year-old civil engineer named Mark living in Nashville. Mark has recently remarried a woman named Sarah, who also has a child from a previous relationship. Mark assumes that because he has a new family, his previous financial obligations will naturally be viewed with more leniency by the court. However, historical trends in American family law show that the first family almost always takes priority in the eyes of the bench. This is known as the first in time, first in right doctrine. If Mark's income remains the same, the fact that he now has a new mortgage and a stepchild to support does not legally entitle him to a reduction in child support for his biological children from his first marriage. Academic textbooks on stepfamily architecture emphasize the necessity of the prenuptial agreement as a tool for household stabilization. For Mark, a prenuptial agreement in 2026 is not just about a potential future divorce from Sarah. It is a defensive wall that protects Sarah's assets from being entangled in Mark's ongoing litigation with his ex-spouse. If Mark and Sarah commingle all their funds into a joint account, a predatory attorney for the first ex-spouse might attempt to include Sarah's income in the calculation of Mark's lifestyle for an upward modification of alimony or child support. While Sarah is not legally responsible for Mark's prior debts, the appearance of a high-income household can shift the judge's discretionary perspective. Step by step, the academic literature suggests that a man must manage the introduction of a step-parent with extreme clinical care. This is the concept of the role of the non-biological caregiver. Case studies in child psychology suggest that when a man pushes his new wife into a disciplinary role too quickly, it triggers a loyalty conflict in the biological children. The children feel that by accepting the stepmother, they are betraying their biological mother. This leads to the defensive exclusion of the step-parent. The textbook strategy for Mark is to remain the primary disciplinarian and the primary point of contact for his children. Sarah should remain in a support role, similar to a camp counselor or a mentor, until a solid emotional bond is formed over several years. Let us look at the granular mechanics of the second family's financial planning. In 2026, the cost of living and the complexity of tax codes mean that men in binuclear families face a unique phenomenon called the double drain. This occurs when a man is paying for the household expenses of his current family, while simultaneously funding the lifestyle of his previous one. Forensic accountants recommend the use of segregated accounts for prior obligations. Mark should have a dedicated account from which all child support and alimony are paid, ensuring that Sarah never feels like her labor is directly subsidizing the previous marriage. This psychological separation is vital for the health of the second marriage. Furthermore, we must address the legal reality of the step relationship. In most American jurisdictions, a stepfather has very few legal rights to a stepchild unless a formal adoption occurs. However, academic texts on family law highlight the increasing recognition of the de facto parent status. If Mark spends 6 years raising Sarah's child and then they separate, he may find himself in a position where he has developed a deep bond, but has no legal standing to request visitation. This is the vulnerability of the modern blended family. The recommendation from legal scholars is to clearly define the intentions of the step-parent role in a written co-parenting agreement with the new spouse, providing a framework for the relationship that persists even if the second marriage faces challenges. Now imagine a character named Julian in Denver. Julian is navigating a situation where his ex-spouse is hostile toward his new wife. This is often referred to in sociology as the gatekeeper conflict. The ex-spouse may use the children to gather information about the new household or may speak disparagingly about the new partner. Textbooks on family systems theory suggest that the man must be the primary shield. Julian cannot expect his new wife to fight his old battles. He must maintain a strict communication firewall with his ex-spouse, ensuring that all interactions remain focused on logistics and that any disparagement is met with a calm, documented legal response rather than an emotional escalation. The academic research on the long-term success of second marriages for men indicates that the most successful potential outcomes occur when the man has achieved what is called emotional differentiation from his first marriage. This means he no longer reacts emotionally to the provocations of his ex-spouse. He sees the first divorce as a closed business transaction. If Julian still feels the need to win or to prove his ex-spouse wrong, he is bringing the toxic energy of the first marriage into the second. This is the primary driver of the high divorce rate for second and third marriages. Finally, we must look at the concept of the legacy integration. In the final chapters of developmental psychology textbooks, the focus is on the multi-generational family. A man's goal in 2026 is to build a structure where his biological children and his stepchildren can coexist without a sense of competition for his time or resources. This requires the intentional creation of new traditions that belong only to the new family, while still honoring the separate histories of the children. This is the mastery of the modern American family. The ability to lead a complex, multi-layered organization with clarity, authority, and empathy. This masterclass has taken you through the brutal reality of the legal system, the cold mathematics of forensic accounting, the psychological warfare of custody battles, and the delicate architecture of rebuilding a life. You have the tools, the data, and the frameworks found in the world's most rigorous academic textbooks. You are no longer a man reacting to a crisis. You are a strategist navigating a transition. The journey of the American man through the divorce system is one of the most difficult paths in modern society. But for those who study the system and apply these clinical principles, it is a path that leads to a redefined sense of strength and a more resilient future. The system is designed for closure, but your life is designed for growth. Use this knowledge to secure your foundation, protect your children, and build a world that reflects the man you have become through this process. The textbooks provide the map, but you are the one who must walk the ground. Build your fortress. Protect your legacy. Start today.